Good morning, this is your Kelso Report for Wednesday, December 7th. I'm your host, Clark Kelso. Custody issues are never pleasant to resolve, but at least when the dispute involves parents and children who are located in California, the law is relatively well settled and the interests of the child are given prominence. But when the custody dispute crosses international boundaries because one of the parents has abducted the child, the case becomes a lot more complex. Our featured case today, Mauricio R. versus L.C., involves just such a situation, and the court struggled to reach a just and proper result under the Hague Convention on the Civil Aspects of International Child Abduction, as implemented by the International Child Abduction and Remedies Act, 42 U.S.C. Section 11601. The case before the Second District arose because the mother, a United States citizen who had married an Italian citizen, took their 5-year-old son away from Italy and settled in Los Angeles in order to escape a psychologically troubled and abusive husband. The husband clearly had serious mental problems and suffered from depression. The mother alleged that he was extremely strict with both her and their son. He was also verbally abusive towards both, including making threats that made both mother and son fear for their physical safety. She also alleged the father had engaged in sexually inappropriate behavior with the son. Notwithstanding these allegations, the actual legal issues before the court were pretty narrow. The mother conceded that under the Hague Convention, the son's country of habitual residence was Italy, and that she had removed him wrongfully without the consent of the father. In these circumstances, the Convention requires repatriation of the abducted child to its country of habitual residence in all but a few exceptional circumstances. The sole function of an action under the Convention is to determine if the abducted child should be returned to the country of habitual residence. The action does not govern the merits of the custody dispute between the parents. The merits are to be resolved in appropriate proceedings in the child's country of habitual residence. Now, one of the exceptional circumstances to repatriation is if there is clear and convincing evidence of a grave risk that the child's return would expose him to physical or psychological harm or otherwise place him in an intolerable situation. And even if that standard is met, the court has discretion to return the child to the country of habitual residence, provided sufficient protections are afforded through the imposition of undertakings or other enforceable conditions of return designed to mitigate the risk of harm. The child in this case was examined by several mental health experts, all of whom agreed there was a grave risk associated with returning the child to Italy without his mother also being close by. The Second District affirmed the trial court's conclusion that there was indeed a grave risk. The trial court then had imposed a number of conditions on the return to Italy, and 2 of those conditions were improper. First, one of the conditions in effect gave the mother a unilateral veto over whether the child would actually be repatriated. The Second District held that this condition utterly defeated the ultimate goal of the Convention, which is prompt and safe return of the child to his or her home country. Second, the father had previously lodged a criminal complaint against the mother in Italy, and the trial court imposed a condition that the criminal charges be dropped. The husband had requested that the charges be dropped, but the ultimate decision on that issue was going to be made by Italian prosecutors. The Second District held that the trial court erred by imposing a condition that would require the father to deliver something that was at this point totally beyond his control. The Second District really struggled with the final result in this case, as it noted, quote, "Whereas here the trial court has determined, based on uncontradicted and compelling evidence, that an unconditional return would pose a grave psychological danger for a child, the court would be remiss not to consider the harm to the child that would be caused by removing him. Nevertheless, in this case, under the Hague Convention, there is no question that the boy must be returned to Italy for custody proceedings. The only issue is how his return can be accomplished with the minimum amount of harm to the child," close quote. Well, the solution for the court was to order the boy returned to Italy promptly, with or without his mother. But in the event the mother declines to accompany her son, the court would then appoint a guardian to accompany him. This is a messy and expensive solution, but one that does seem compelled by the terms of the Hague Convention. Custody disputes that cross international borders are not easy cases. Our first one-liner involves a public works contract in West America Bank versus City of Berkeley. The First District interpreted statutes dealing with a bank's obligation as a holder in trust of retention funds to deliver those funds immediately to the city upon presentation of a proper claim by the city. It is common in public construction contracts for the government entity to retain a percentage of the monies already earned by a contractor to ensure satisfactory completion of the work. These are called retention funds. Pursuant to applicable statutes, a general contractor may place securities of comparable value into escrow as a substitute for having the government entity actually retain the retention funds. This permits the contractor to earn the interest on those funds instead of the government entity. According to the statutes, the escrow agent must immediately convert the securities to cash and distribute it to the government entity upon 7 days' written notice by the city that the contractor has defaulted. Well, the City of Berkeley issued just such a letter. But the bank refused to distribute the funds because the contractor, which claimed it was not in default, sent the bank a letter demanding that it not distribute the funds at peril of being sued. The bank filed an interpleader action. The First District held that the interpleader was improperly filed, since the bank could not show that it was likely going to be subject to conflicting liabilities or double vexation. The applicable statutes provided that the bank would be held harmless against any claim that it had wrongfully distributed funds to the city, so long as the city sent the proper demand letter for distribution. So in these circumstances, the First District held the bank was fully protected from any conflicting or double liabilities and was equally unlikely to find itself subject to multiple lawsuits, given the clarity of the applicable statutes. The court dismissed the interpleader. Next, in the area of health law, in Steiger versus Flippen, the Fourth District held that the Medical Board of California had power to issue an administrative subpoena directed at the Southern California Permanente Medical Group as part of an investigation into why an 805 report detailing work restrictions placed on a doctor within the group was not sent to the medical board within the 15 days required by the statute. That's a big deal because a willful failure to file an 805 report in a timely manner can subject a doctor to a charge of unprofessional conduct and a fine of up to $100,000. It's pretty serious stuff. The medical group argued that the board's jurisdiction was limited to individuals who were licensed by the board and are actively practicing medicine, and did not extend to a group of physicians such as the Southern California Permanente Medical Group. Well, the court disagreed with that and said the board does have jurisdiction. And that was a pretty easy conclusion to reach, since the medical board statute gives it jurisdiction over, quote, all persons, close quote, subject to the Medical Practice Act, and the Medical Practice Act expressly includes various organizational forms as persons. And in any event, the 805 report was submitted by the CEO of the medical group, and the board plainly had jurisdiction to investigate the late submittal by the CEO, and that included any incidental investigation affecting the medical group. Seems to me it's a pretty straightforward holding, and given the prevalence of medical groups as the structure of practice in California, it's a perfectly sensible holding to give the medical board jurisdiction over those groups. And that's it for today's Kelso Report. Have a great day in the law.